be seated. Morning, Your Honor.
Number 5 on court's calendar, Fernandez Saldana, and number 6, Shanna Gardner.
Middle. So. Just got a second.
Good morning, Your Honor. Patrick Brody for Ms. Gardner, who's present, and Mr. Bias and Mr. Sullivan are on Zoom listening room.
Good morning.
Good morning. Wait a minute. Who is that?
That looks like a guy from Fields Automotive.
All right. Officer Sidney. Sir, turn your camera on, please. Officer Lynn.
I got it, Your Honor.
All right. Okay. Where's Mr. Bias?
Mr. Bias is in a place where
I
he's not
thought you
able
said he was
to.
on Zoom.
He's listening, Your Honor.
Oh, okay.
Yes, sorry about that, Judge.
Okay.
I will be speaking the least today, so.
There was a gentleman from Fields Automotive, and that didn't look like you. Okay.
No, it's not me.
All right, on my desk, there's a defendant's motion to schedule evidentiary hearing and memorandum of law.
Yes, Judge.
Obviously, it just got placed here, so I haven't read it. I was trying to read it quickly. Do you want to give me just a moment?
Yes, Judge, that's fine.
Okay. What's the state's position on Ms. Gardner's motion?
Your Honor, my position remains as it was last court date. I do think she's entitled to a bond hearing on her motion. We're prepared to respond and prepared to have that hearing. I just believe that for the record's sake and for appellate purposes and to avoid prejudice to the state of Florida, we need to handle the disqualification motion prior to proceeding with our hearing. I've spoken with defense counsel this morning. I think we are close to requesting, I won't speak for them, I'll let them do that. We're close to requesting both the disqualification hearing. I've floated some dates with defense counsel. I'd be requesting we set the motions filed by defense regarding the disqualification the week of March 11th, and Ms. Gardner's Arthur hearing the week of March 25th. And I think that's very reasonable, given the amount of evidence the state's going to have to present to prepare, file our written response to their bond motion, and handle this other pending matter.
All right, let me, first hear from you, Mr. Carty. What's your position?
Judge,
On those dates.
Judge, I would need to speak to the other counsel involved in the case before I was able to confirm with the court.
Okay.
We've asked.
I mean, as far as the way that I'm reading your motion to schedule the evidentiary hearing and memorandum of law is that you believe that the state of Florida has had sufficient time. You wish to push forward regardless of the court's ruling on a disqualification. Am I reading that incorrectly, or?
No, Judge, that's our position, and one of our major concerns is if we are successful on disqualification, we'd be back before the court with a new state attorney's office, and they'd be begging the court for more time to get up to speed on the case before they could have the evidentiary hearing. So it's our position, and our first available date is March 5th, and we'd ask for March 5th, Judge.
So I'm looking to essentially your second sentence in the second paragraph, which says, while the law is clear that a trial judge, upon a motion to disqualify him or her, which that's not necessarily the case, you're asking to disqualify the state, must first rule on the motion for disqualification.
So, Judge, that was referencing a motion to disqualify the trial judge where it's an all stop and the judge can't rule on any other motions. Right. There is no case law similar for a motion to disqualify the state attorney.
So it's your position that it is not an all stop?
That is our position, Judge.
Are you taking into consideration what has been alleged against the state? And to me, it's a little bit different. So let's say it's the evidence that they potentially would produce to the court, which is one of my concerns about hearing any motion. If there's contested evidence, right? And then that would be presented in front of the court. That's what I don't know. Like, obviously I haven't seen it, I don't know. Do you have any of those concerns if we went forward with the bond hearing?
Judge, I have some concerns.
Based on your review?
Based on my review, I don't know any other way, Judge, because my client's been sitting in custody for a long time now. The state has had an awful long time to prepare for any evidentiary hearing on a bond. I mean, I think it's disingenuous for the state to say they need more time to prepare when they've already presented this case to a grand jury, and they're well aware of all the evidence out there. To our knowledge, they've completed all testing. So I wouldn't understand how they would need more time to prepare. But with regard to the the court's position about whether or not we have concerns, we do have concerns, but the alternative is that Ms. Gardner stays in custody until this disqualification issue is resolved. And I think, Judge, once you hear what we found out during the depositions this week, you're going to see that this is much, much bigger than any of us ever thought a week ago. And I can tell the court what happened.
Really?
Yes, Judge. I can tell the court what happened during the depositions this week if you would like to know.
So, because you share in those concerns, right? And I'm concerned, and I've always been clear about that with the parties, right? So ever since you all filed this motion with the court, to me, because there is no guidance in a situation like this is probably, I don't know if it's a first impression, but at least it hasn't been litigated on an appellate level. It seems more practical to me to handle the disqualification. I'll give you the time. I'll make the time. if you all are prepared, I wanted to do it sooner rather than later, and then I could still honor all of the things that you put into this motion. I'll give Ms. Gardner the hearing that she's entitled to.
Yes, Judge.
Right? But if you all have concerns about potential evidence that they would present in order to meet or not meet their burden, then I'd rather hear that out first. And I do understand the concern about getting up to speed. Let's say hypothetically I do disqualify the state attorney's office. I'm cognizant of that, but you know, the state should be able to burn the midnight oil in my mind and get that prepared. So
Your Honor, this is Jesse Dreiser on behalf of Mr. Fernandez, and we didn't do our note, and Mr. Hill is present, Mr. Tassoni as well.
Thank you.
Your Honor, I don't know how clearly I stated this in our motion to disqualify. I don't know how clear.
Mr. Bias, not all people.
Yeah.
You have to talk in the microphone.
I don't know how clearly I stated this in our wherefore clause, and I may amend to make this very clear, but it will be our position that not only are we asking you to disqualify the entire Fourth Judicial Circuit, when the governor, I assume, does the governor's assignment for the new prosecution team, we're going to want all of the electronic data to be sent to a new filter team so that there is no way that this can happen again. So that the new state attorney that gets the case has it completely sent through a filter team so they don't end up with our text messages, our emails, our attachments, our timelines, and every other thing that the state had access to and is in possession of. So that's going to be another delay that the state can't burn the midnight oil on, because that's going to have to happen in our minds for this case to be secure and non-prejudicial to the defendants.
All right. Do you want to tell me what your position is based on the discovery that you conducted?
Our position is we're ready to go. With the exception of time that we need to get the transcripts from the depositions, so I would say 10 days. The state did speak with us this morning. Their timeline was acceptable in terms of our issue. You know, the bond issue is not our issue. That's Ms. Gardner's issue. Tangentially, though, it does affect, because what you're saying is, what if the state uses the document that I'm highly contesting, or the text messages that Ms. Gardner is highly contesting against Ms. Gardner in her bond hearing? That would pose a problem for me. Because again, it would be one more person, you or anyone else, that would have access or actual knowledge of what's in that document. So I don't have a suggestion there, but I do have the same concern that you were sharing this morning, for certain. I can't predict what they may or may not show.
Okay.
And Judge, we are going to supplement our motion as the court asked us to inform the court today. And we're going to move to actually dismiss the indictment, Judge, based on the fact that the state and its law enforcement officers, and this is sworn testimony, were reviewing both Ms. Gardner's iCloud return and her Google Drive return before it ever went through the taint team, that was knowing and intentional acts by the law enforcement team that was working with the state, and that when they had questions when reviewing those about whether or not something they were actually looking at was attorney-client privilege, they would call Ms. Stifler and ask her, describe it to her, and ask her if what they were looking at was in fact attorney-client privilege communications. And so it's our position that the spillage of her attorney-client information throughout the law enforcement teams, which are Category A witnesses expected to testify in this trial, will amount to sufficient prejudice that we can never put the genie back in the bottle and Ms. Gardner can never get a fair trial. I will let the court know that we have some research to do. We are not taking this lightly. We want to make sure that we are able to adequately support the assertion that I just made to the court before we file our supplement. But we do think that what we established during the depositions this week, in fact, one of the things we learned, Judge, is that my client's iMessages from her iCloud, which we all know did contain attorney-client communications, were circulated to all or most of the primary members of the law enforcement team by email before the taint agent, who was never trained and had no protocol and had never done this before he even looked at them. And that the spreadsheet with all these messages that was circulated was open and reviewed. And that the law enforcement members did in fact identify attorney-client communications in that spreadsheet, which was by another court's order, right, in February of 2023. All of that was supposed to go through the taint agent before anyone that was part of the prosecution team looked at it.
Okay. So what do you all want me to do?
Judge, I would ask for 2 weeks for us to file our supplement to the motion to disqualify. I don't know how long the state would need to respond to that. And then
So that's still putting you off the timeline that you're indicating.
I know, Judge, but I'm stuck between a rock and a hard place. And so,
Do you want a moment to try to talk to your colleagues?
yeah, well,
Really, his client.
yeah,
my client.
yeah, let me, one moment. Judge, I've talked to my client and we agree with the court's assessment earlier that if we can resolve the disqualification motion in a timely manner, we can then set the bond motion.
Okay,
And that satisfies the concerns that Mr. Fernandez has, well, Your Honor.
okay. And you talked to him about it? I mean.
We're in a different posture. I don't need to talk to
Yeah.
Mr. Fernandez.
Right,
He-
well, this is the thing. You all know, I have not seen one shred of anything, and before, this is the other thing I was gonna ask you, is it your thought, so you're gonna supplement, right? The state's gonna respond. Is it your thought that I do need to ask the chief judge to appoint another judge to review this material, or is there an agreement on it?
I spoke to the state and Mr. Carodi, and I'm just addressed for the record. I don't believe we need another court. The emails, the text messages, everyone and their brother had them in this case, far before Next Point even became an issue. And the documents that the state intends on using against my client, they've seen, they've read, they intend on using them. If the court, if you see that document, it makes no difference. That privilege has been eviscerated unwillingly by the defense, and I would say that if there was any concern for the court, I would waive any ability to recuse the court based on this very limited issue, because, if the court has some concern, like, well, then I'll see it and then the defense will try to recuse me. Absolutely not. I think this court is the proper place to hash all of this out.
All right. Am I understanding? Before, there was an agreement that certain documents, certain communications, those things, my understanding was there was a great majority of the information that you all were talking about was agreed to by the state of Florida, that was attorney-client privilege. Is that still the case? Or are you still, my understanding was only kind of one document or thing
Right.
on Mr. Fernandez's part. But the state indicated it was evidence. This defense said it was attorney-client privilege, and it was my understanding, it was only one contested document. Is that still the case?
There's
Right,
there's one contested document that the state is in possession of, admits that they've looked at and intends on using. That's what you're speaking of specifically.
Right, and so I'm
There are-
asking, is that still the case, yes or no?
Yes, there are hundreds of what the state agreed to were privileged communications that were uploaded to Next Point that the agents had access to, their position is, yes, they were privileged, but no, we have never looked at them. No one has ever looked at them, albeit everyone had access to them. Their position is no one's ever seen them, except for the one document. So
Right, so I can clarify, sorry, I know, I don't mean to interrupt Mr. Dreiser.
You're fine.
But I somewhat agree with what's being said. I do think that the depositions made clear, and that's been, the information brought out depositions is the information contained in the state's filed written response. But we have been clear from the beginning, there was an agreement between parties to send cell phone devices, MacBooks, Apple Watch, and an iPad through a taint team. The Jacksonville Beach Police Department executed over 70 search warrants in this case, including to Google and to iCloud. They received that information directly as the affiant custodian of those records. Those records are at Jacksonville Beach Police Department. Just like any other evidence for any case will be stored with the presiding law enforcement agency. There is one document that we discovered while reviewing this evidence that I believe is evidence. I don't believe it, one, it's a communication, or two, it's confidential, or in any way a privileged attorney-client communication. That document was brought to my attention by our analyst. I reviewed it. I determined that there was nothing about it that suggested it was from an attorney to an attorney, etc. I mentioned it to Mr. Dreiser, and we are disputing that one document. The rest of what they're talking about is the state of Florida never had possession of any of these items. They were in the possession of a law enforcement agency. Once we realized that there were attorney-client privileges, documents, or text messages on this information, which we had purposefully taken folders, left them sealed and zipped, and didn't review them. The analysts were reviewing other evidence that was not attorney-client privilege. Those were then sent through the taint team. The state of Florida and law enforcement has never read any emails, any text messages, any client communications other than this one document. The state attorney's office agrees. I read this one document, I intend to use it. So I just want to be clear about all of that because Mr. Peroty's saying he wants to dismiss the indictment and needs to do research to adequately support his assertions. I just want to be clear at this point they're assertions. We have no, I haven't seen their supplemental motion yet. I think I have previously said that the communications, I took Mr. Dreiser, Mr. Peroty, Mr. Bias's word that whatever emails and text messages were privileged, I took their word that they were privileged. We didn't look at them, we removed them, we deleted them, we sent them through tape teams. To the best of our ability, we tried with good faith never to purposefully or intentionally read anything. Any disclosures or any possessions were inadvertent, and we took whatever steps to remediate our possession of these when we realized that we had things we were not supposed to have in
Can
our
I
possession.
ask you a question? Do you believe, based on what Mr. Dreiser is saying, okay, that the court could just look at metadata and not the exhibit? Do you understand what I'm
I
asking?
understand what you're saying.
So
I don't think you-
file, give me a second.
Yes, ma'am.
So file A, okay, if I don't need to see the contents of file A, that's why I'm asking you all this question. I don't see the content of it. If you all agree that it is in fact attorney-client privilege, there will be no need for the court to examine that document, then to determine if whoever had access to it. That's what I'm asking. Are y'all agreeing or are you not agreeing? Or is the agreement just as to one document, or are you all saying it's multiple documents? And if it's multiple documents and there's no agreement, I'm gonna disagree with you, Mr. Dreiser. In an abundance of caution, I ask the Chief Judge to have someone else review it, settle your disputes, and then I'll look at the metadata.
And Your Honor, my response to that would be, I have not seen anything or reviewed anything other than the document we're disputing is privileged.
two documents.
Two documents. Actually, one of them I reviewed, one of them I was told about the contents. I have not seen or reviewed any of the, I think he said 66.
It was also
emails.
sent to you, and in the same email,
Yes.
two
So
documents.
y'all will talk to each other. Is there an agreement or is it not?
It's a little bit more complicated. I know,
I'm not in
we're not in agreement that the one document, that is going to have to be reviewed by the court. The
Okay.
other documents, which are emails, text messages, and phone calls, there are over 100 at least communications. There's no question that they're privileged, and there's no question that they were uploaded to Next Point. The only and I wouldn't allow, it would be over serious objection by the defense that anyone ever get to look at those. So no court is ever going to get to look at
Okay,
those.
Give me a moment. Do you agree?
I do not. I believe that part of their argument, because my testimony and our response and what I believe will come out of the hearing, is nobody from law enforcement and the state attorney's office looked at any of those items that they're talking about, the text messages.
I agree with
the
that.
emails.
So
Can
why
I
aren't you
please-
agreeing that they're attorney-client privilege?
Because I don't know what they say, and I don't dispute that there are communications between them and their clients. My issue is the prejudice, which is the second prong of their motion. If these emails and text messages are about scheduling, and the court's gonna disqualify and dismiss an indictment because we had theoretical access that we could potentially hypothetically open a scheduling text message, I think the court needs to weigh that of how prejudicial the mere access is. Putting aside the fact we didn't read them, the fact that I have a closed sealed envelope on a table next to me, it matters to me what's in that envelope because they're saying it's a communication. I'm not disputing that, I take them at their word. But what it contains is relevant to the remedy that they are seeking, because they have to prove that they've been materially prejudiced in some way. The state of Florida has somehow inured a benefit to trial by having access to this information, that I will have evidence I should not have had, that I will have trial strategy I would have otherwise not known. So I believe that an independent magistrate should review it. And I will point out that when we had this agreement in front of Judge Carbula on their motion for protective orders to stop us from doing a forensic extraction of the phones, they were in favor of a magistrate reviewing everything. So at some point, we were all in agreement to detainting. They wanted a magistrate to review all the communications and remove attorney-client and marital privilege. The court said, no, the state can look at marital privilege. There was no court order. We agreed. We are not going to look at attorney-client privilege. We don't want to look at it. We have no intention of looking at it. Anything that has happened has been inadvertent and has not prejudiced them. So the contents of those messages are relevant to that prejudice, that finding of prejudice or non-prejudice.
With the exception of two documents
Yes, and I'm
titled
conceding
confidential communications sent by Miss Butler to Miss Stifler before the taint agent ever got a chance to look at them. And our expert's going to come in
I'm fine
here.
with the court reviewing those two documents because I don't believe they're communications or privileged.
Our expert's going to,
They're contesting them.
and our expert's going to come into this courtroom and say that on such and such a date, Mr. Fernandez emailed our office and our attorneys only those documents. The taint agent is going to come in and say, had I seen the email with the attachments, they would have been privileged and I would have filtered them out. That's what we heard this week in the testimony.
All right. It is very clear to me that sooner rather than later, and when I say sooner, does Ms. Gardner share the same concern?
Judge, our
The
concern.
same,
Our concern is slightly different in that, Ms. Stifler spoke about there was an agreement with the cell phones and somehow that agreement didn't apply to her iCloud that was seized after the agreement that everyone knows has the same text messages that are on her phone. And so I guess what I'm hearing the state say is that because law enforcement couldn't look at the phone, they went and got her iCloud.
I just want to be clear
okay.
about that. What I'm saying is, we had an agreement, we attempted to honor it, we were dealing with hundreds and hundreds and hundreds of megabytes of data. We did our best to send it through the filter team. We made extensive efforts to prevent disclosure of attorney-client privilege. The two documents he's referring to are just evidence. I had no idea they were emailed to Mr. Reiser by his client. I found them from an independent source. But I just want to be clear because they keep saying these things on the record that I dispute. And I just want to clarify the record. I think that we need an independent magistrate to review everything because I think that prejudice needs to be determined. And if Mr. Dreiser and I are agreeing whether the contents of this document are even a communication, then I'm not comfortable with Your Honor reviewing it.
I've said this from the outset. A court hearing a case of this magnitude, okay, I want to avoid any appearance. I appreciate the,
It's fine. We don't
I
object.
appreciate the thought expressed by you, Mr. Dreiser, but my concern runs deeper than that, okay? So I've said it from the outset. I'm the one that offered it. I've talked to Chief Judge Day, and he's willing to expend the resources. However, I am going to request, it is very apparent to me that that is a necessity. And I am also cognizant of the time frame and the work that all parties have put into it, both the defense and the state attorney. That's why I need a clear understanding of where your agreements are, where your disagreements are, because I don't want to send this to another judge with you all still essentially disputing or arguing about what the magistrate is, or the other judge is going to look at, okay? So, I'm going to ask the chief judge to appoint another judge to review these materials. I don't want to have access to it. I don't want to review it for a number of reasons, and I think it's only judicious and fair that if it is contested, what these documents are, whether they're privileged or not, a judge then ultimately, let's say we go through hypothetically an entire trial, there would be no way to any imposition I would have. Like, I don't want to have access to something that apparently or may not rightfully be a part of this case. What I do need the parties to do is based on your discovery. So we have these initial motions. Ms. Gardner says she's going to amend. Mr. Dreisler, are you amending or no?
If I did, it would be of no real significance, just to make sure my remedy is clear and maybe add what we believe we learned in the depositions. It would not be of any significant,
Okay.
but I'll have it done whenever.
This is what I need you all to do. I need you to supplement both pleadings with what is in fact contested, okay? What is agreed to and not agreed to. The agreement should be, in my mind, the first part of the supplement. These now 2 documents that the state has admitted and then so that is the first part. The second part should be what you all do not agree to, what you want the magistrate to look at, so you can, out of this terabytes and terabytes of information, to hone in. And this is all for efficiency, and also if you want a decision done quickly, that you all kind of narrow the issues for the judge. I'm going to ask the chief judge to make the appointment. He should be able to do it hopefully by the beginning of next week. I need you all to supplement. How long would you all need to identify those things?
Despite how we're talking on the record today, I think for the most part, we actually agree on a lot of information.
I agree with that.
So
That's not the impression you've given me.
That's my morning report. Actually, Mr. Dreiser and I and Mr. Cody and I spoke this morning. I think a lot of these things there's little dispute as to certain pieces of the evidence. Our dispute is to the law and the remedy. So we will get together and we will come to some understanding.
Well, Matt,
What I'm understanding from you is that you want the magistrate or the judge to look at certain portions that you have not seen in order to say if it's to separate that these documents or these files or these, whatever it is, this is related to scheduling, therefore.
Right, I don't know what they are, but I think it is germane to their remedy they're seeking as to whether it prejudices them or not. The fact that I merely have access to their scheduling, I'm using that as an example because obviously I don't know what's in there. But it makes a very big difference if they're discussing their trial strategy versus if they're discussing scheduling.
From your deposition, were you able to kind of like narrow that down, or is it just hundreds and hundreds of files or things? Or
I narrowed the scope of the depositions to the documents that are in dispute. The other emails.
How about we start with that?
The other email?
What do you all think about that?
Here's the
Start
problem.
with that.
Here's the real next big issue with another magistrate reviewing all the emails, which in a vacuum, I don't have a problem with it. That magistrate, what Mrs. Stifler was referring to in the initial hearing, was going to be a magistrate, a special prosecutor, or a filter team person. I would have had no problem because they're totally isolated, and I assure you that person would have never reached out to Ms. Stifler to find out whether something was or was not privileged. But in this case, if the magistrate's gonna do that, and the magistrate may have, or the circuit court judge, whoever Judge Day appoints, and then has questions, the state attorney's office is gonna have to bring in a special prosecutor to handle those hearings. It'll be like a federal castigar hearing, where the AUSAs have a whole nother team to handle the hearing, because during that hearing, they would be potentially accessed or being asked questions or being asked to argue
Go
that.
back to my original question.
Yes.
What about, we start with the 2 documents that you all contest,
That's fine with me.
and then we table what Ms. Diffler is suggesting.
Sure.
Then you all don't have to supplement, you all can identify, we know what it is, right?
Absolutely. There's no confusion about those documents, who had them, when they had them, what they intend on using. That would be very simple for this. There still needs witnesses and a hearing to hear the timeline. But yes, we can absolutely start there, Your Honor, and perhaps finish there.
That seems more prudent.
Yes, ma'am.
I'm in agreement.
There we go. It happened.
Told you.
Where's Ms. Gardner in all this? Do you agree or no?
Yeah, Judge, we're gonna supplement, I think our basis is gonna be a little different, and that is, we believe that what we would call the state's effort, and by state, we mean the law enforcement team that's working with the state attorney's office, right? One state, organization, that our concern is the effort to do an end around the court's prior order regarding the taint team by looking at the iMessages from the iCloud and the Google returns. So I don't think there's a dispute that there were attorney-client communications on, on those returns.
Is this something that you discovered during the depositions?
Yes, we had no idea. We had no idea that anyone had looked at her iMessages before the taint team was, or taint agent, because it wasn't a team, it was one agent.
Now I'm gonna ask you all this, to settle that issue, would you like another judge to hear that, or can you agree, or would you rather me deal with it through the metadata?
I think for that issue, based on what the deposition entailed with Ms. Butler, which this was outlined in the state's written motion, so to me at least it was not a surprise. She discovered an attorney-client communication while reviewing something and realized it hadn't been properly detainted, and then we sent it. That one communication, I think an independent magistrate could review. I never reviewed it, I don't know what it contains, but she could tell that judge in camera what it was without the state attorney's office present, and I'm fine with that.
Do you agree?
Yes, Judge.
Okay. Let me ask this. Have both defense teams seen that? Do you want a separate hearing for each defendant, or do you want to have it concurrently?
When it comes to their messages, I don't know
So
what
you're
it
requesting
is.
separate hearings?
Yes, Judge.
Okay. All right.
Yeah, maybe, Your Honor, for judicial economy, a lot of the same witnesses, it may be the same hearing for evidence, and then just like a Castigar hearing, I would be asked to be removed for a portion of the hearing.
Obviously, I'm not going to conduct them, so I'm just trying to
Okay.
be as detailed as I possibly can with the request that I'm asking the chief judge to do, so that he can communicate and figure out who he would like to appoint. So what I'm asking, what would be required of the other judge, which is, my understanding, which I'm going to repeat back, is that you all have a contested document on Mr. Fernandez's behalf, two contested documents, and then on Ms. Gardner's behalf, there is a communication that was not, that was communicated to law enforcement, and
Two documents and one
communication.
message or text or something.
And I don't know exactly what the ATF analyst reviewed, because I obviously did not ask her that in an open deposition. So it would be a questioning for the ATF analyst exactly what she has reviewed.
All right.
And because I know that the iMessages were circulated amongst at least 4 law enforcement officers, I do not know yet if any of them reviewed them also before the detained agent was able to go through. In full disclosure to the court, we may stumble upon someone that's reviewed more than the ATF analyst.
You didn't ask those questions during the depo?
So,
How, if it was communicated to anyone else, or whether she talked to anyone else?
well, the problem is what she said is that she got the iMessages in an Excel spreadsheet that was emailed to her, and that there were detectives and other federal agents on that email. Obviously, she can't speak to whether or not those other people that were on that email did in fact review the iMessages. We've not deposed those individuals. I don't believe I've gotten a copy of the email that was originally distributed to know who exactly was on that email.
I don't, I can get it, I can make those people available. I will say, I mean, they can check them out, I don't have to take my word for it, but Ms. Butler was our analyst, so she was always the first and only person to receive and begin analyzing the evidence before everybody else did. So it's unlikely, but obviously I will provide those names and I'll get that email.
All right. How long, I'd like to do this sooner rather than later.
We
Do
need
you want to come back next week?
for the,
Or, so, based on my understanding and the parties, Ms. Gardner is going to supplement, correct?
Yes, Judge.
All right. How long do you need for that?
Judge, I'd ask for 2 weeks.
Okay. In the meantime, I will ask the chief judge to appoint an independent judge from this case. When do you want to come back for your,
to set, all we need really is the 10 days for the transcripts.
when did the depo occur?
Tuesday and Wednesday.
There really wouldn't be a need for me to see you all. The appointment can be made, and then the scheduling would be with the other judge. I can put this on for status.
Yes, ma'am.
Yes, Judge.
So you need 2 weeks. You need time to get the transcript, which it looks like, by my count, the earliest the transcript would be ready would be February 29th. If I count 10 business days, if you ordered it.
We did, and Ms. Butler chose to read. I don't know how that delays or not.
Okay. So, would you all be prepared to supplement without the transcript or no?
Judge, I believe we would, based on my notes from the deposition.
Okay. What does your scheduling look like in early March, so I know when to bring you back for status? What I'm saying is you would appear in front of the appointed judge, okay, to review. I'm assuming that judge will need time in order to process and do an order. I can come back
March 4th?
March 4th, anytime that week, or the week of March 11th, you can let me know where you are with the other judge. if you want me to do that, or, I was just gonna set this for a status at this point.
March 4th for a control date to see where we are with the other judge would be fine with the defense teams, Your Honor.
Yes, Judge.
Okay.
Your Honor, can we do March 5th? The co-defendant is set to appear in the court.
I'll reset this date.
Perfect.
You want the 4th?
Yes, ma'am.
I just set that as a status, on the Tenon case, knowing that, these cases would dictate a court date for him, okay? So, we, on both, Mr. Fernandez and Ms. Gardner, we will come back on March 4th, 9 a.m. status hearing.
I have one clarification. Mr. Carodi is requesting the names for the email with the spreadsheet. Because we're in this situation, how do you want to receive that? I'm not going to ask that they forward me that email because they're contesting that it has privileged communication on it. So
I would imagine like a PDF or a printout and scan of the email itself that just shows the attachment would
She's
not.
asking you, she doesn't want to get it and give it to you.
Right. How do you want
How
to
do you
receive
want to
it?
get it?
Ms. Butler can just forward it to me.
Okay, I'll have her do that.
Judge, I don't know that the email itself would be privileged. It's the attachment that's privileged. That was just the point I was making.
How do you know it's in it? I thought you haven't seen it.
I haven't, but the way it was described to me was it was just forwarding an Excel spreadsheet with the iMessages in the Excel spreadsheet.
If you'll have,
Yeah. That's fine.
the agent forward directly. Okay.
And then, lastly, Your Honor, the motion for our mitigation specialist to go to the jail, we're working directly with the general counsel from the city and the chief of the jail to resolve this issue, and I believe that we're going to be able to self-resolve it.
You are? Okay.
I think so.
All right. Anything else we need to take up?
No, ma'am.
No, Your Honor.
So, obviously, when the chief judge makes his appointment, that will be communicated to the parties. I will see you all back on March 4th, 9 a.m. for status of both cases. Thank you all very much.
Thank you, Your Honor.
May we be excused? Thank you.